AI law developing rapidly. Almost every week sees a new development in the field of artificial intelligence law. Computer scientist Stephen Thaler, who has made many efforts to define and push the boundaries of intellectual property law in connection with AI, contended that his computer system, Creativity Machine, had autonomously generated work of visual art he called a recent entrance to paradise, as shown here. When he sought to register the copyright for the work, the U.S. Copyright Office initially rejected the application, as current Copyright Office rules require human authorship for copyright. Thaler argued that he was entitled to ownership of the copyright to the art, as a work for hire, since he is the owner of the Creativity Machine. The court agreed with Thaler that copyright law has proven malleable enough to cover works created with or involving technologies developed long after traditional media of writings memorialized on paper. However, said the court, underlying that adaptability has been a consistent understanding that human creativity is the sine qua non at the core of copyrightability, even as that human creativity is channeled through new tools or into new media. The court agreed with the Copyright Office that human authorship is an essential part of a valid copyright claim. The U.S. Copyright Office also refused to register a visual work that included elements generated via AI. The work was entitled Theatre d'Opera Spatial, and submitted by Jason M. Allen. The Copyright Office determined that the work contained more than a de minimis amount of AI-generated content, and that Allen had refused to disclaim ownership of the AI content in his copyright application. He used a generative AI tool called Midjourney and guided it using a series of 600 prompts to create the final work. The AI issue only came to the attention of the Copyright Office because Allen's work was the first AI-generated image to win the Colorado State Fair's Fine Art competition. The copyright examiner then sought more information about Allen's use of AI. When he refused to disclaim the AI elements, his copyright application was denied. The Copyright Office had previously announced that when a work has both human-created and AI-generated elements, the human elements can be protected via copyright law so long as the AI-generated elements are disclosed in the copyright application and thus excluded from copyright protection. On August 30, the Copyright Office announced that it was undertaking a study of the copyright law and policy issues raised by AI systems. To that end, it is seeking input, including from members of the public. Need to copyright your work? Book an appointment with us at www.eonlaw.com. Eon Law. Unleashing Genius.